Well, international humanitarian law applies only in times of armed conflict, whereas human rights law applies all the time. And human rights law is much broader, so it would cover freedom of expression, freedom of assembly, questions of privacy, whereas the law of armed conflict, or international humanitarian law, really covers what happens on the battlefield and the treatment of detainees and those sorts of things. Well, it's become a very contested area as to when one area of law has exclusive competence over the issues. So there is a certain amount of blurring now in war crimes law, where human rights law has started to enter into the law of armed conflict and expand some of the traditional war crimes. Similarly, in the area of detention, there's some blurring as to whether or not you can demand access to a judge when you've been detained in the context of an armed conflict. So those issues are currently being fought over, and it's not that clear where the dividing line should be. If you are accused of war crimes and you find the definition of war crimes expanding and you've done something which is now a war crime whereas before maybe it wasn't, it's bad news for you. On the other hand, if you're the victim of one of those war crimes, you might find that that's good news. And of course it gets more complicated still when we're talking about targeting, other questions related to detention. It may be that you need to detain people and that would protect the human rights of the people they would otherwise attack. But of course if you're being detained, you see this as an unreasonable expansion of the rights of the government to do things which otherwise it couldn't do. So it does rather depend where you're standing.